episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Welcome to Surviving the Survivor. It is a show that brings you the very best guests in all of true crime on trending criminal cases. And this one, I have got to warn you, is very disturbing, but important. And we'll find out from one of our guests why, who is a victim's rights advocate, why this is so important. But first, just a little bit of background. It was a chilling scene inside the courtroom today in Orlando, Florida. Stephan Sterns, he's the man accused of murdering and R-ing, I don't say the word on YouTube, 13-year-old Madeline Soto. Was his girlfriend's daughter. Jen Soto is also at the center of a lot of this. People wondering why she has not been arrested, and we will ask our former homicide prosecutor in this very county about that, if she could potentially face charges. But Stephan Sterns appeared in court today, and the goal here is to suppress the digital evidence. Police found a mountain of digital forensic evidence, mainly photos and videos, too disturbing for most to even think about. And now the defense says, hey, wait, those were basically taken illegally and they should be banned from the trial, which is really, excuse me, the crux of the government's case. And again, we've got Ryan Vescio, I'm going to introduce in a moment, who knows Orlando and the courtroom system in cases like this, like nobody else, because he worked and tried homicide cases in that very county. But Sterns, he didn't actually get on the stand today, but he was sworn in today, and he offered some explanations and testimony from where he was sitting with his defense counsel. The evidence includes hundreds of sexually explicit photos stored in his Google account and his devices. But his defense again argues he only consented to a limited search. Without further ado, our best guest, and we do have the best guests in all of true crime, Ryan Vescio. He is a former homicide prosecutor in the great city of Orlando, Florida, a criminal defense attorney. He works with Mark Najam, one of the more prominent criminal defense attorneys in all the nation. And then it's been a while, but great to see her back. Sunny Slaughter, the best name in the business, next to maybe Shaquille Oatmeal, one of our mods. But Sunny Slaughter is here. You see underneath, a law enforcement expert. She trains law enforcement officials, a litigation consultant, and she herself is a victim, was a victim of DV, and speaks about victims' rights. And we're happy to have her. And last but certainly not least, and I can't bring him up yet because he's not here, but he's supposed to join, is John Tompkins, who is a very savvy criminal defense attorney out of the great state of Indiana, who came to our attention during the Delphi case. Now, I always like to bring a little bit of levity to all this. So I have a little bit of a wider shot. I am convinced, again, that there's a ghost in my studio. The camera keeps moving, but I noticed in the corner there, next to that little blue circle, there was a gift that the COE had given me after a night where I shouldn't have said stuff that I said. And that gift is someone pointing at me with a finger that is not the thumb or the index finger. And it has a little thing under there. And I thought it was maybe inappropriate, so I have moved it out of frame. And that finger is now staring right at me. So I guess it's serving its purpose. So here we go. So Ryan, we're going to play clips today, and this guy is very creepy. Now, of course, there is the presumption of innocence in this country, although sometimes I feel like that's almost skewed because of the court of public opinion. But this is him in court today. This is some B-roll. I'm just going to mute it because we don't have, you can hear the shackles kind of jingling, but we see him with his haircut, head shaved, looking like a legit, inmate, I guess you would say. The charges here: first-degree murder by strangulation. He is reported and accused of dumping 13-year-old Maddie Soto's body in a rural area in Osceola County. I mean, this guy creeps out a lot of people, including myself. But he's also facing 60 counts of sexual abuse that spanned multiple years. Now, the defense is obviously, and these are public defenders, so I think you actually may even know, but they've got to do what they've got to do. And so they're saying, look, you took this cell phone evidence, this digital evidence, without his true consent. And this is really the crux of the story today. We'll break it down. Any surprise to you here at all that the defense is trying this?
No, not at all. You got to throw everything up against the wall in a case like this where the evidence is overwhelming. So they actually would not be doing their job if they didn't raise these types of issues. Now, all lawyers in all 50 states and in the federal system can only file motions if they have a good faith belief that there is a debatable issue for the court. Now, defense attorneys have the right to reasonably rely upon the representations of their clients in filing those. So for most of the people watching, it looks like he consented and that's it. And why are they wasting the court's time? But as you said, he is presumed innocent at this point until a jury finds him guilty. Now, with that being said, the motion is, I mean, thin at best. I wouldn't walk across it because I'd fall into the frozen lake because there is evidence that he did give consent. And what the defense is trying to do here is parse consent out to, well, he consented to one thing but not the other, and he didn't mean it, and he didn't understand. But the defense is doing what they have to do here.
Yeah, I have to agree with my man Myron Sanchez, Miami Myron. He is a monster. Again, look, one of the arguments that the defense made too, Sonny, is that the media should be kept out of this because shows like they actually put our logo up there, I guess, which is a quasi badge of honor. But they said, look, shows like ours and others, of course, are swaying public opinion. But Sonny, I'm just interested. And first of all, welcome back. It's been a while. And we have to get you on more regularly. But again, I told you I just every day try to stay above water here. So it's nothing personal. But you know, for the victims' families, and this is obviously an unusual circumstance because it's his now, I guess, ex-girlfriend, unless she's still dating him. But you know, extended family, Maddie's biological father. When you start bringing this in, the digital forensic evidence, you're obviously pulling on heartstrings, really emotional heartstrings. What do you think it's like for the family members, you know, who loved Maddie? And sadly, I don't know how many of those there actually were. I'm sure there were some, but it's an unusual circumstance. I know her father obviously is heartbroken, the biological father. What do you think the impact of hearings like this is on the family?
So before I get into that really quick, thank you, Joel, for having me back. It's really good to be back. And also, I am an FDLE instructor. I'm a Florida Department of Law Enforcement instructor and have been for several, probably going on 4 years now. And I travel across the state of Florida, and I looked at this and kind of was unpacking whether law enforcement did what they need to do, because I'm the executive leadership law enforcement instructor. I'm also the Fox 35 in Orlando expert too. So I did see your logo because I actually commented on this case when the defense went to talk about the media not being in there. So I did 2 appearances for them. And as it relates to the family, Ryan, let me just say it's great to be on with you and the great work that you are doing there in Orlando. But I know that really translates across the state of Florida and beyond. So thank you for that and for what you said earlier, that, you know, defense counsel is doing what they do for families. And when we think about Madeline's family, I know we talk about her mother because that is the only person that we are currently seeing, and we have seen some evidence, you know, of her biological father. But family is a very unique word when it comes to victimization and criminal behavior, and that the family, Her family also includes her her friends that she went to school with, the neighbors and that saw her regularly, and those that interacted with her. So she has an entire community, as well as all of us across the world, who have such empathy and feel such pain for her horrendous lifestyle and her horrific murder. And it is difficult for her biological family, for those that were close to her, because it is difficult for all of us who may not have known her before this, but we absolutely know who she is now. And to tie in all of what we have heard, and that's only scratched the surface for what he is alleged to have done with other things, and looking at the 60 additional counts. This is a painful trial. And because I also have a personal experience, my own daughter was the victim in an SA case. And actually, to the man that I was married to, he is now deceased. I did not kill him, but he did go to prison for a very long time. And did I know? Absolutely not. And that was for his sake. But I have concerns about Madeline's mother, because, see, I was not a protector. And she seems to be in a mood that is unfamiliar to me personally, but professionally, it is not all that unique in and of itself, her behaviors.
Yeah. Well, Sonny, I heard you talk about this, so we appreciate you being open with us, and know that was obviously a very difficult time in your life. But Ryan Vescio, to Sonny's point, are they done yet with Jen Soto? Do we, is it possible that they are still looking at her closely? A lot of the behavior, without getting into all the, the nooks and crannies here, was odd to say the least. You just heard Sonny talking about being a protector. It seems like she was not a protector as a mother. I guess legally, my question would be, what does a mother have to do to protect her child, if anything? And could she still face charges? And John Tompkins is setting up backstage. We're going to come to him in just a second, but go ahead, Ryan.
So, I mean, almost anything is possible. It's possible that you and I are related, even though I don't think we are. But I think,
I could only dream.
Well, the honor would be all mine. But I think as it relates to charges against Jen Soto, I think that ship's already taken off. At this point, they're so deep into the case that there would be no reason or there'd be no advantage to charging her this late into the case. Now, what parents are required to do is they're required to step up and protect their children. And it's really, really simple that, and as Sonny was talking about, lots of parents get into this position where their spouse or the person that they're dating are doing these horrible things. And because of cycles of violence, because of being afraid not to be heard, they're reluctant to step up. But if a parent knows their child is the victim of abuse or neglect and fails to do something about that, here in Florida, that's a crime. And in most jurisdictions across the country, that's a crime. And, I think one thing that's important for, our watchers tonight and everybody else to know is, even though these are really hard situations, there are a tremendous amount of resources out there that can help protect parents who want to do the right thing, but have either been victimized themselves or have been threatened to not say anything.
Yeah, and that's a great point. We should actually do a show about that one day, COE. What can parents do who find themselves in a difficult situation? Because you heard Sonny talking about it happening in our own family. I think it's more common than we think. Just to fill in some of the history of this case, February 25th of last year, so it's only a year ago. Some of the cases we're covering, going on 14, 15 years. But it was last year that Maddie turned 13. February 27th, that was on February 25th of 2024. February 26th, she does not show up to school at Hunters Creek Middle School. On the 26th and 27th, Sterns is interviewed by police. He's subsequently arrested. And then March 1st, very sadly, they find Maddie Soto's body in a rural area of Osceola. We're going to get to the quote unquote testimony in a moment. The COE pulled some clips, and shout out to she and Space Coast. Again, we go off pool cameras and the audio was horrendous. So Space Coast did what he could to fix it. Annie K, who's a regular in the chat. Thank you, Annie. And John Tompkins. I'm coming to you. John, by the way, I mentioned is a criminal defense attorney and a very good one out of Indianapolis. Hey, STSers, how can the defense, John, argue that some evidence be allowed from the cell phone and some kept out? Is there ever a valid objection? I started by asking Ryan Vecchio, who is a former homicide prosecutor and criminal defense attorney. And by the way, Sonny is a victim's rights advocate who you're on the panel with. I started out by asking Ryan, they have to do everything that they can possibly do. By the way, look at that tree behind John Tompkins. This is why I don't live in New Jersey anymore. It is April 23rd. April 23rd, right. And that tree is barren, man. Not a leaf on that tree. John Tompkins, it ain't worth it, man. Retire. You got enough money. Move down to Florida. You can't be living in a place where there's no leaves on trees like 10 months out of the year. But I feel bad for that tree. That tree needs to be replanted in Miami.
How's that?
Yeah, that's better. It makes me feel better. Okay. Actually, I like looking at, I don't know, people. It's my sadistic nature. People are still living in this horrible weather. But anyway, John. So, the defense here. I mean, they essentially had to file this motion, but it seems like it's going to be an uphill battle.
I think so. I heard the testimony today. There was a little bit of, I think, mixing of issues. They talked about how they were whether he was in custody or not. This is a search and seizure issue, not a Miranda issue. I think there might be a valid issue because consent can be limited, and the requirement is that the consent has to be knowing, intelligent, and voluntary. And what the defendant seemed to be saying was, I only consented to them looking at my maps. I didn't consent to them looking at everything in my phone. And we, in the defense bar, are having success with too broad of searches being granted on phones. When you want to search a person's phone, the warrant requirement is that it be specific and articulate exactly what you're looking for. And you can't just go on general rummaging. So with the state responding, basically saying, well, he was there and watching what they were doing, I think they're trying maybe a tacit consent. He must have consented as he watched. I know in Indiana and in most federal jurisdictions, that wouldn't be enough.
Right.
And generally, the burden is on the state to show that a warrantless search was valid. I don't buy that there was an exigent circumstance. They knew that the phone had been factory reset, so they weren't going to lose anything that hadn't already been lost. And they had the ability to seize the phone and wait over time to get a warrant, because they weren't going to let him back into that phone or to let him go to some place where he could have signed into a computer and tried to erase the cloud.
Yeah. John, I'm going to keep you on mute just because we're hearing a lot of ambient sound, and I will unmute you. I'm sure I will forget. Shout out to Aria Dakota Grimaldi Lane, another great name. It all rhymes, and she is coming to us from the UK, lest you think we are not a global show. So just to break this down a little more, and then I promise we're going to get to some of the courtroom goings on today. The defense argument, essentially, Ryan, is, look, this phone was searched without a warrant. Sterns only agreed to let police, quote unquote, check Google Maps. He claimed he didn't understand the extent of the consent. This goes back to the Fourth Amendment, search and seizure stuff, Ryan. So, I mean, every single time, I mean, this is just standard playbook stuff, I think, where the defense is going after the police investigation, the way they went about it. I guess the question here is, the police are on scene. They ask him, they ask him verbally. He says yes. He hands over the phone. What are you not allowed to do at that point? And apparently they asked him repeatedly for different things verbally, to which he all said yes. Now you're a defendant. You don't have a lawyer present. You don't know the law. So what are his rights here?
Well, he has the right to not consent to a search. He has the right to require law enforcement or the government to go articulate probable cause to a judge to get a warrant. to search the phone. But in the same sense, he also does have the right to cooperate. And you do see this a lot with criminal defendants, to where their belief at the time is, if I cooperate some, then they're just not gonna look at me anymore, and I'll look like I'm a good guy, and they'll move on. He should have shut up. He should have never gave consent. Now, in the same sense, what you see here is that there was some level of consent. Law enforcement at that point in time had what they needed to get a warrant. And Sonny could talk about, it's always safe. And when I was prosecuting, I'd always advise law enforcement, if in doubt, go get the warrant. Hold the phone, and it's going to take you 2 hours to type the warrant and go to the warrant judge. And in this jurisdiction, like a lot of jurisdictions now, warrants are submitted electronically. It's not that you got to drive to a judge's house at 3 a.m. and wake them up anymore. So law enforcement was eager, and there was a lot of pressure on them, and they made a tactical error. Now, whether or not the judge suppresses the evidence, I'm not too sure about. But Stephan had the right to just stand there and not say a word. But he chose not to.
And by the way, the judge has not ruled on any of this, but is expected to rule shortly. Sonny, just to Ryan's point, a hypothetical. I'll ask John one more question, and we'll get to the video. But Sonny, let's say police, they show up at his house, they're talking to him, and they say, "Can we look at your phone?" And he says no. To Ryan's point, I mean, what would they have done? What could they have done? They would have had to wait those 2 hours. Do you know if they could have held onto the phone until that time?
Well, first, they have to have probable cause first, and then they need to get the warrant, because when I put on my litigation consultant hat and I have to look at their process, I am going to hit them, whether the court hits them or not. I am going to hit them with the risk and liability of not getting the warrant, of not using your body cam footage. All of these things play critical in a case, because you need everything on tape. You need to follow through. You need all of it. But he could have been detained for so many hours. That would have given them time to get the warrant. They could have just been standing there if they had to. But not having the warrant, not being very specific, and I've had a case like this before. I'm always asking, did you have the warrant? I'm looking at the paperwork. In some jurisdictions, you need to have the warrant physically in hand. You can have it on your phone. That's the same thing. You don't have to necessarily run. But I ask those questions of defense attorneys if I'm the person working with them, because I work defense and prosecution. What is the law and what is the practice in your jurisdiction? I think we could have avoided this. Now, I hope that the judge does not throw this out. I hope there's enough of the other evidence and issues to say it was a technical error and something, but they're not going to throw it out, just like he did with the media not being in there. But I always say, if necessary, err on the side of caution, because it messes up the actual prosecution of the case.
Yeah. By the way, Lee brings up a great point, John, here, that they were trying to find a missing. At this point, they thought that Maddie was still missing. Waiting 2 hours may have been too late if she'd still been alive. So, John Tompkins, does that change the police dynamic at all in terms of having to see that phone to try to get information?
It does. It may introduce an exigent circumstance, but again, they've got the problem of knowing the phone has been factory reset. When did that come into the equation? When did they know that? I was listening for the state, and I'm going to change topics a little bit, but still on this search and seizure and whether it was okay to do this. I was listening for the state to argue inevitable discovery. In other words, phones don't really hold data that much. It's usually apps and third-party databases that have all this data, even if you wipe the phone. So I think the state might have argued, or maybe in the future will argue, well, even if we didn't have the phone, eventually we were going to find this data through these apps and those servers. So now Indiana doesn't recognize inevitable discovery. Maybe Florida doesn't. It is alive and well in the federal jurisdiction, but they can get that information. Now, back to your question, and sorry to deviate, but in that moment, if they think that there is information on that phone that will lead to her location and they don't know where she is, maybe that's an exigent circumstance, but the defense kind of built that in. They said, well, he told them he could look at the maps. He consented to the maps. So that would take the exigency away. He consented to the maps. Why do you need to look at anything else right now? It's an interesting issue.
Yeah, for sure. All right, let me just go to Ryan on this real quick, because Ryan, you've explained this before. Now, this SA trial, they're being like bifurcated. So they're doing the SA in one trial, the murder in another, and this SA trial is set to start May 5th, just because every other trial, Ryan, that I was supposed to cover has been continued. I'm now taking it personally. Do you think there's a chance that this is going to be continued? And why, again, explain why they're doing this as two separate cases.
So doing a motion to suppress 2 weeks before trial, when you've had a long runway, is not common. So I do anticipate that the case will be reset and not go to trial in May. So I think that's the first part of it. There's a few reasons why these two cases are separated. First of all, the defendant has an absolute constitutional right to ask a jury to judge the facts against him, only related to specific charges, unless they are sufficiently connected with each other. And at this point in time, the state has a tremendous amount of evidence on the homicide and the cover-up and those sorts of things. We also know what was happening to Maddie at the time over this long period of time, but the state has not been able to concretely bridge the two, that the homicide occurred because of the SA. Mm-hmm. That's where Florida courts are definitive that severance of the cases is not only appropriate, but is oftentimes reversible error. We want to hold people accountable for the act that they're alleged to have committed, unless certain circumstances from an evidence stance apply. The reason that the state is also doing it this way is that one of the aggravating factors in Florida for seeking the death penalty is having a prior violent felony conviction. So they're trying the SA case first because those charges qualify as prior violent felonies for purposes of enhancement on the homicide to warrant the death penalty. So the state has several aggravators in their homicide, but if Stearns is convicted of the SA counts, one or more of those, they then become admissible in the penalty phase of the homicide if the state gets a guilt phase verdict of murder in first degree.
But if I heard you right, you think it's going to be continued?
I do. Normally, this is the digital evidence isn't the entire case on the SA case, but it is the majority of the evidence. I don't expect in a motion this important that the judge is just going to rule from the bench. He's going to do an order in writing, because if he denies the motion to suppress, it's automatically going to be raised on appeal as an appellate issue. If he grants the motion to suppress, in Florida, the state has the right to take a mid-trial appeal. We call them interlocutory appeals. So the state can go and say, judge suppressed our evidence, he shouldn't have. And because of that, they need a written order to do so. Just looking at the time now, I don't anticipate the judge is going to drop a suppression ruling 10 days before trial, because then if he grants it, the state's got to assess whether they can go forward. If they deny it, that may change some of the defense strategy going forward. So the attorneys have been diligent on this case. Judge Carson, who's deliberating over this case and hearing the case, I've known Judge Carson his entire time on the bench. I knew him before he was a judge. Is very, very good. He was a longtime criminal defense attorney, so he completely understands the rights of the accused. He was also a prosecutor at the beginning of his career, so he understands what the state's going through as well.
Yeah. So, I guess my next question, John Tompkins, just from a legal standpoint, since and Sonny, I'm coming back to you. This is a very tenuous situation, because if this evidence is suppressed, the state loses a massive part of their case, right? And the defense, a huge win for the defense. So I guess if you're either side, how do you prepare? And just explain a little bit more what Ryan was saying about the judge and how he might rule on this.
Well, you're right. This digital evidence is a large part of the prosecution. I think that the state would need, or would certainly ask for, time to reorganize their case and their evidence, their exhibits, how they present their arguments. Now, it's not the only evidence. I think they could still go forward. But part of that is seeing how far, when you suppress, there's this fruit of the poisonous tree doctrine that says not only do you suppress that evidence that was seized, but you suppress everything that was obtained directly or indirectly as a result of the evidence. So even the ruling may not tell us the full impact that we see of what the suppression is. Now, it is very tenuous, and I was really shocked to hear the process that the police went through in seizing the phone and searching the contents of the phone. Now, seizing the phone would have been easy. You talked earlier about, well, what could they have done if he had said no? Well, they could have secured the area. Like if they want to search a house, they can bring everyone out of the house and have them wait outside for a reasonable amount of time, the time it takes to get a warrant. Here in Indiana, you can get a telephonic warrant in under an hour. It's not a huge imposition. They could have held that situation in check, not allowed him access to the internet or to the phone, and been applying for a warrant. In fact, in Indiana, they probably would have been applying for a warrant in the other room telephonically while the interview is going on. They do it over radios, for instance, from the field in Indiana. And I was really surprised to hear that process hadn't at least started while they were asking for consent.
Yeah. By the way, you can hear kids playing on the playground behind John, which is kind of fitting and also sad and haunting for this story, because sadly that is not going to be a reality for Maddie Soto. But Sonny, one more question to you, and then we'll go to the video, I promise. So the prosecution is arguing, the government here, that Sterns did in fact give verbal consent multiple times. We talked about that. He was not in custody. He could have left. He was standing right next to the detectives and saw what they were looking at. And then this exigent circumstance, they say, of factory resetting the phone to delete evidence, which they say is a legal exception to the warrant requirements. What about that exigent circumstance? The fact that there was this factory reset, which is tough to do. It's not like you just hit a single button. You're asked a few prompts to do that. Your thoughts on all of that, Sonny?
I think it interviewed by Detective Tagler and Detective Acosta on February 27th. Is that correct? Last year?
That's correct.
And pursuant to the questions you were just asked, you had indicated that you did not consent to the search of your cell phone.
I consented only to looking at the Google Maps and checking see if I was not doing Google in the first place.
Did you have the opportunity to see what law enforcement was doing on your cell phone?
No, the Acosta was still talking to me until we walked away and began searching all the things that he did not consent to.
Isn't it true that she actually handed your phone back to you?
My phone was she trying to input my phone because it had locked itself.
And Detective Tagler actually mentioned looking at your history, which you okayed, correct? Your Honor, can we approach?
Yeah, come on up.
This audio is very poor. We tried to fix it as much as we could. This is part of the courtroom pool camera. Ryan, I'll be honest, I'm having trouble making this out exactly what his answers are. But what about the line of questioning? That's much clearer.
Yeah, the state, there's a couple things happening here. The state's trying to extend the consent as much as possible. And the concept of tacit consent or consent by acquiescence is really, that's a tough legal hurdle to get over. And what's interesting about this line of questioning is a couple things. One, the prosecutor doesn't really look prepared to be able to respond to these questions, which happens sometimes. Two, oftentimes you don't, as a prosecutor, you don't get to question a defendant, especially in a pretrial hearing. So I think that leads to the point of the state's trying here to get out as much as they can. Now, what we can make out of Stephan Sterns' comments is that he wants to really drive home I allowed them to do A and B, but not C and D. So in this matter, though, the state's got to do whatever they can to try to get the scope of the consent as wide as possible.
Yeah. Ryan, just to tack on to what you were just saying, why do you say, I mean, I think this is relatively not that common. You can correct me if I'm wrong, to have a defendant give testimony in a suppression hearing like this, but why would the prosecutor not be as prepared as they should be? What's making you feel that way?
Well, it isn't common that a defendant, especially in this type of case, is going to testify about anything. Really, most of this is all documented by audio recording, video recording, body cam recording, and that's what shows. That's what shows what the interactions are, and frankly, it's the best evidence of what the interactions are. The defense has to be careful, because the moment they ask their client, "What were you thinking?" that then opens the door to all sorts of items that a prosecutor is going to be able to walk through. It seems to me, just by both the questions and the demeanor, that the prosecutor didn't seem fully prepared to go down this whole litany of questions. Normally, when you're cross-examining somebody, you know what you're going to say. It's short, it's succinct, it's to the point. It is not necessarily scripted, but you know exactly where you're going, and it's got a cadence to it. Where here, it's write a note on the piece of paper, reflect for a couple of seconds. What about this, or what about that? Which is a little surprising to me.
Yeah. By the way, John is just resituating, so I bounced him out for a minute or two while he gets situated. To you, and then I'll keep playing this, even though the audio is horrendous, and I was warned about it. But Sonny, what do you make? Ryan just mentioned sort of his demeanor, his courtroom posture. People are like, this guy sounds creepy. He uses this almost Lori Vallow-like male version of a baby voice. What do you make of all this?
You know, from the very moment that we saw him, remember when he and Jen were together and they were being questioned by law enforcement, and, you know, it would seem, and he was answering the questions. And he has this Lori Vallow arrogance almost, that he has it all together. He is not hostile. He looks pleasant. He seems pleasant. He's cooperating. So that type of narcissistic arrogance that's subtle, not abrasive, that's what he has always given to me. And I think he is playing this the way, and this will sound weird to folks, he's playing it the way that it needs to be played, because he knows his culpability in everything. So I mean, he's going to argue, I gave them consent, not that much consent. Ryan, everything that you said, I absolutely agree with. They've got to play this really well. And I know a lot of times people get upset with the defense attorneys and, you know, they get upset with the prosecution. Just know everybody is doing what they need to do from their lens and from their perspective and from their practice. They are doing what they do. And we cannot take it. The case is very personal, but I don't think it's always helpful when we lash out at, well, the defense shouldn't do this. Well, that's what they're supposed to do. And the prosecution is arguing it the wrong way. Well, they get hit with lots of turns and things that happen, and they have the burden. So I think we just need to focus on what the evidence is, and hopefully we will get in what we need to get in. Just like we got Lori, I do not think that, even though this is pressure for all of us, I don't think that he'll get away with any of this.
I hope not. Tom Honecker here, he thinks he's the victim. I don't doubt that at all, which is interesting. And this is also interesting because I think it's true. People don't like to hear this, but according to his mother, he has a high IQ. I don't doubt that he's an intelligent guy, which makes it even more, I think, reasonable for the state's argument that he knew what was going on when law enforcement was talking to him. So let's continue to play this out and see. Again, apologies. It is beyond our control, but here we go. This is more of Stephan Sterns just a few hours ago in an Orlando courtroom. Now the lawyers are obviously going up to the judge. That bailiff is that deputy's keeping a close eye on him.
100.
Yeah.
And the cell phone in question was in fact your cell phone.
Yes, it was.
I don't have any other questions.
Thank you. Can you redirect?
The very classic one question and out. Don't end on an objection.
Okay.
No, you're on.
Rye, I'm sorry. Say that one more time.
Yeah, I mean that's the classic. You just lost at a bench conference and you want to sort of try to leave control, so you ask the one obvious question that really doesn't need to be answered, and then you get out of there. So that's sort of the litigation licking your wounds and trying to show that you haven't been killed at the bench.
Ryan, by the way, how does all this work? So this judge, you say you've known forever, and then you go up maybe and have a case in front of him, and then you see him down in the cafeteria or wherever. What's it like when you bump into a judge down the hall after you've just tried a case in front of him or a hearing?
It can be an interesting dynamic, but the reality of it is judges are just like people. And, there are some judges I know that I see out occasionally, and we talk about our families and we do all of that. And there are also, I tell you, a very, very quick story. I mentored and helped to supervise a local young attorney at the state attorney's office who has now progressed their way up and is on the state Supreme Court. And I ran into this judge at a bar conference and came over and said hello. And we talked about our kids. And I said to her, well, I think you get it right most of the time, but sometimes you're just completely off the point. And everybody laughs. And, there's a lot of professional sort of in the trenches moments with judges and attorneys, and especially in situations to where, as a prosecutor, I tried cases against a defense attorney who then became a judge 6 months later. And there's a lot of things that go on behind the scenes where I've had some judges that'll call both prosecutors and defense attorneys to their chambers to informally talk about cases, to flush issues out. I've had judges on both sides, both as a defense attorney and as a prosecutor, tell me, I'm going to let you do what you want, but you got a real uphill battle here. You really need to think through, do you want to go through with this? It's if you do it the right way, it's always professional. And there's a way to tell a judge you got it wrong without being a jerk about it and making it personal. But a lot of litigators have a real hard time with that.
Yeah.
I might be one of those if I was a lawyer. Vanilla Rose. Good thing I'm not a lawyer. Sonny, I'm coming back to you, I promise. But Ryan, this is your kind of your wheelhouse. Couple of comments here. This case especially makes me certain I'd never be able to be a defense attorney. I can't fathom fighting for suppression of evidence that is unequivocal proof of this thing's guilt. And then followed here by Mimi's Love, and there's another one too. Defense attorneys fight to put really bad people back on the street. Why are they not affected by these terrible facts? How are they okay putting essayers or unalivers back on the street? What is your response to that, Ryan? I mean, defense attorneys are core to the United States criminal justice system. I mean, we need them, but it's, I don't take this the wrong way, maybe a necessary evil. I have no idea, because a lot of times they're defending guilty people. How do you respond?
Well, I mean, look, we could have 5 shows. We could have a week just on this topic. I mean, I can kind of share my evolution of this, because I was a, young, hard-charging prosecutor, and I had a lot of the same opinions. And where I came to realize is this: everybody deserves to have their constitutional rights upheld. And when we allow people's constitutional rights to be determined on what they did or what they may have done, then you erode the thing that makes America the greatest country on the planet. Now, there's a lot of things to this, and being a defense attorney in these types of cases, it's not always about getting the assayer or the unaliver back on the street. A lot of times these cases come down to what should happen. If this is a grand theft at a football game of a purse, okay, a lot of times those cases come down to, is there sufficient evidence to prove? But in these types of cases, 90% of the time, the evidence is overwhelming. I mean, it just is what it is. You have the best law enforcement with the best resources and the best crime lab analysis and all of that marshaled together on big, serious cases. So oftentimes as a defense attorney, for me, it becomes a matter of who is my client and what realistically should happen. As we've talked about, for 11 years, I did nothing but homicide prosecutions and handled about 145 death investigations. I could think of 4 people off the top of my head that are in this type of category, to where, frankly, they needed to be buried alive and then reburied twice because they were so dangerous. Most of the murderers that I prosecuted did awful things. And it's not to say that their background was justification for what they did, but the question becomes, at some point in the future, should they have an opportunity for redemption? And that's a really complicated issue. And I think, as Sonny said, these are emotional cases. So defense attorneys are not cold to the allegations and are not cold to the autopsy photos and the scene photos. But they do play a very necessary role in the criminal justice system. Yes. And finally, like everything else in life, there's a lot of different types of attorneys. There are some criminal defense attorneys that believe that their zealous representation of their client means to push the envelope as far as possible. And that's not always right. It's often hard to tell a client no. And what we say, and what Florida law and the law in most jurisdictions says, is that clients have a right to make factual decisions. whether or not they're going to testify, whether or not they're going to call a witness or not. But if a client wants an attorney to file a frivolous motion, the attorney has an ethical and professional obligation to not file it, even if it makes their client mad or even if it makes the client want to fire them.
Thank you for that thoughtful answer there, Tom Honecker. We could do a whole series on this, I think. But I feel, Sonny, this is for you, and then we'll get back to the sound. I feel for the phone technician and the police that had to look at the images on his phone. You can never unsee those, erase those from your mind. So really, I mean, so there is, you know, you've got people peripherally involved, like these people, the digital forensics experts who are going to see images. You've got the Ryan Vescios of the world. You've got Will J, who Ryan knows is going to prosecute this case, and he has to look at these images. What do you think the impact is like on these people, Sonny, especially long term? You cannot unsee some of this stuff.
Well, because I specialize in crimes against persons and sex crimes is one of my biggest things, along with human trafficking cases. This is something that I have had to do in plenty of cases. And one of the things that I will tell you, Tom, great question. It is extremely difficult to work these type of cases. And what happens is often, and we do this on the federal side because I was a Homeland Security law enforcement instructor and expert. And we try to, and I'm sure some departments do it as much as they can. So you get to do the work for so many hours and look at the material for so long before you have to have so much time off. Now, when you have short resources, that may or may not happen. But when you have a lot of images like this that you have to look at, there's often a break that is required mentally, like days off where you need to have a break. If you are the person working a case for an extensive period of time, you will also may have to go through, speak to a psychologist every now and then to reset every couple of days, maybe every couple of weeks or so, to reset, to ensure that you are mentally well to keep going. There are things that I have seen in some of these photos that I will never forget. But also, I want you all to think, when you're thinking about this with law enforcement, juries do the exact same thing. They're often charged with looking at things that they can never unsee. And one of my critical things in some of the work that I've been doing lately and talking about lately is how these things impact our jurors, and they don't get to unsee this in the courtroom, and they also don't have access to the mental health services that is necessary, because these cases and the images that they have to see is not for everyday consumption. And I am talking about, I have worked some very horrific cases involving infants and adults and things that you don't want to talk about. These are not the things that people want to do. And just really quick to piggyback on Ryan, a criminal defense attorney is defending the Constitution, because everyone in jail and everyone in prison is not necessarily guilty. And we have to weigh and balance the justice system very uniquely. Someone has to defend even the worst of the worst. Brian Stevenson said, "We are all better, more than the worst things we have ever done." Some people are not redeemable. Most people are. But we have to play out the justice system in the way that it is. And in these type of cases where these visual pictures of children and others are so horrific, we have to really think about and ensure that our justice system is balanced at all times.
Well said. It's obviously super complicated. Someone here says those laws are for humans. Monsters should have their own set of laws, but then we get onto a very slippery slope, I think. So I'm going to finish. Yeah, I'm going to finish playing this out, and then there's one other chunk, and we'll get final thoughts and wrap this up. But this is the end of Sterns' kind of brief testimony from the defense table.
Court's going to find that there has been record evidence to establish that Mr. Stearns was the person that was affected by an alleged violation of his Fourth Amendment rights, that the property alleged in that violation was admitted to be his. And I'm going to find that the burden has indeed shifted to the state regarding the defense's motion to suppress evidence obtained from the unlawful seizure and search of the cell phone. State, do you anticipate presenting witnesses or evidence?
Yes, Your Honor.
Thank you. I'm going to call your first witness.
The state will call Detective Francis Hunt.
All right, so they call it. By the way, real quick, that is, you can't really see him right now, but to the right of the female prosecutor is Will J, who's going to be leading the case, and he's the guy who wears funky socks, which you can't see right now. I'm going to pull up the. He's always got interesting socks on there. There was some. Oh, Ryan, I was going to ask you before we play this next bit of sound, and we'll play this out. It's going to be, a chunk of sound, but we'll play it out straight. This issue of resetting the factory phone, where does something like consciousness of guilt fall in the landscape of the law? Can the government say, yeah, look, he did this. This shows he's guilty?
Yes, at trial, consciousness of guilt is a very strong weapon that a prosecutor has. For purposes of a motion to suppress, it may or may not be relevant, just depending upon exigent circumstance or things like that. But consciousness of guilt evidence is always beneficial. And it oftentimes comes as a result of two things: either the defendant who's just dumb and does things to try to cover things up. But I've seen this throughout my career with somebody of the modality of Stephan Sterns, where he's got an average to above average intellect. He's obviously a schemer, has some sociopathic, narcissistic type of mental health struggles. And what they do is they think that they're so smart that they're not thinking about 5 steps down the road. They're thinking about right there and then, and they set themselves up like this.
Yeah. By the way, people have been asking. I did do a read rant on day one, and then I went 25 minutes without missing a beat. And then the COE says to me, yeah, I don't think we should play this. I don't think we should put it to our video or whatever. I might do a weekly rant recap at the end, but the COE and I discussed it in detail, and this is exactly why I am making this a Karen Reed free zone, because even the COE and I cannot agree on what is acceptable when it comes to that case and what is not. And Space Coast, look at him, ever the wise man on the West Coast, just posted on Twitter. Space Coast wants nothing to do with it. Okay, so this is now the defense asking detectives questions here. We're going to watch this. I apologize if it's a little lengthy, and then we'll just get some final thoughts on the back end. Here we go. This is earlier today. Stephan Sterns.
He or she? He? Did he tell you to get a warrant?
He did not.
Okay. Did he tell you to try and get that cell phone downloaded?
He did.
Okay. And how did he tell you to get that cell phone downloaded?
He didn't. He just said we wanted to get the phone downloaded, and that's when I asked Stephan if I had his permission to download the phone or if I needed to get a search warrant.
Right. You gave him the ultimatum at that point, right?
I asked him 2 questions.
Okay. So we can either get the phone or you can get a warrant, right?
Correct.
Now, at any point during these interactions, did you ever tell Mr. Sterns that he could have his phone back?
I told him his phone was going to be downloaded overnight and that he should probably get it in the morning.
Okay. And prior to the second interview, did you ever tell him he could have his phone back when you just took it?
I did not.
At any point, did you ever apply for a search warrant to download Mr. Sterns' phone?
I did not.
Did any other detective do that?
No.
Okay, because you're relying on that consent, right?
He gave us consent to search his phone.
It's a yes or no. Were you relying on consent or did you get a warrant?
He gave me consent.
Now, when you're speaking with him, you became aware that Mr. Sterns had taken medication, right?
He said he had the night before.
Okay, and that was Ativan?
Yes.
And he told you why he took that medication, right?
Because he said he couldn't sleep and that he was very stressed and couldn't stop crying.
All right, so that was just a piece of the detective being questioned by the government there. One of the interesting things, Ryan, is you also hear this, and if you haven't caught this, we had homicide detective, Las Vegas retired homicide detective, Phil. It was Phil Ramos and Dr. Detective Troy Looney who broke down this interview with Stephan Sterns. But in the interview, Ryan, he tells police, I'm a little foggy because I'm on medication. I assume, Ryan, that defense attorneys are going to jump on that and they're going to say, look, this guy was on lorazepam, whatever the hell it's called, and didn't know his ass from his elbow. How can you guys question him? What happens in a situation like this, which is inevitably going to come to fruition?
Well, and it goes right to the determination of whether he gave knowing involuntary consent. Now, you have to look at the whole picture. Lots of people take medication every day for various things. So the fact alone that he's taking even a controlled substance doesn't mean that he can't give knowing, intelligent consent. Really, what you want to look at in these situations, Joel, is how is he acting? How is he responding? Is he falling asleep? Are his answers non-responsive? I mean, it's kind of like the old Chris Rock joke where 2 + 2 = Jello. I mean, if they're saying things that are just completely non-responsive, out in left field, if he's sitting there drooling, okay, then I've got some stuff to work with there. But it really is the whole picture. But this is one of the prime reasons why law enforcement does interviews on video. And now with how prolific body cameras are, it really is a new piece of evidence that even when I started prosecuting 20 years ago, we didn't have.
Yeah.
Well said. Sunny Slaughter, it has been way too long since we've had you on. She, as you heard, works training here at the FDLE, the Florida Department of Law Enforcement. They're kind of the overarching law enforcement agency in the great state of Florida. She's also a victim herself. You heard the man she was married to was doing things he shouldn't have been doing to her daughter and went away for that. So my question to you, feel free to give us any final thoughts, Sonny, but I have, believe it or not, my own hesitations about covering this as a father of 2 daughters and a son. It's just, this is the most disturbing kind of, I talked about this with the COE. Do I want to sit in a courtroom now that I'm not beholden to a corporate entity like I used to be? In other words, I'm no longer a prisoner. Love you, Fox News, but I'm no longer a slave to corporate. Come at me, Fox News. I dare you. So, now that I'm a free man, I don't have to cover this, but I sort of am very interested in this case. But what is your advice? We talked about the family. What about people who are interested in watching a trial like this, who are following this case? This is as depraved, awful, and horrible and terrible as it gets in one trial. What is your advice to people who are interested in following it? Maybe next to Karen Reed. That's a joke. Sorry. Karen Reed is not go ahead, buddy.
I love that nobody wants you to cover Karen because it's a mess. People always ask me this: how can I do this, and how can I focus on this type of work after what happened to my daughter? Well, it's because it's what I do, and you have to separate somebody has to do it, and I'm really good at this. I'm really good because I actually not only have the professional expertise, but then I have a very unique lens as a mother, as a woman. I can get all the feels with other women. And I tend not to criticize those who said I didn't know, because I'm telling you, I didn't. Hell, I'm from New Jersey, Joel. You know, I am a straight up Jersey girl, gangster person. But what I would say to your audience and those that want, this trial is horrific, like any other trial, and particularly because it involves a very young girl who was trusting and who did not have anyone to protect her. If you want to stay involved and know the outcome of this case, I say take it in small bites. Be slow to anger with the defense and the prosecution, because this is a learning journey. These cases are very unique in and of itself. Joel, I know you have the babies like many of my, our folks on here. When you have children and when you know children, I did a TEDx talk about my case. And if you all go, this is not a plug for me, but if you listen to my TEDx talk, I actually say, do you have children and do you know a child? All of us do. And it is incumbent upon all of us, even when it is painful, and especially as parents, to see the warning signs, to get to understand them, to understand the process. So while we might be mad, if we know what is happening, if we have an understanding, we can go from being mad to empowered and empower others. We can become a support system for others who may be going through things that is hard for them to talk about. Take this case in small bites. Learn, listen, and learn. Sometimes we listen to respond instead of listening to learn and hear. And I think that's what's important. We have an opportunity to change from the inside out because we become more aware of things that are going on. And yes, she absolutely had no protection. The mom should have protected her more, but we can tell our children what to look for. We can tell others what to look for. We can then identify what we see, what we suspect, and act accordingly. But we can't do anything if we are constantly on the run from the things that are really happening in our world today. Not all of us should be immersed, but we should all be educated and empowered so we can change the circumstances of those who are vulnerable, who are victimized, and who cannot do for themselves. So Joel, you have the best guess, not even talking about me, what John and what Ryan brought to the table, and everyone else that I know has been on your show as they cover this case and others like it. And as all of your followers get to see what you are talking about here, it is an opportunity to become aware, to empower others, and to change the circumstances of someone who is silent. My daughter is 30 years old now. She is a mother herself. We are all very close. But when I tell you this did more damage to my family than anyone could ever imagine, and not just for when the light was on, but for decades. Decades. This is a pain that does not go away. But you know what we do now? We can talk about him. He is still the father of my children. So they get in me what they would not have gotten if I didn't come to understand. They get to say the things that they want to say because he was still their parent. They get to have all the feelings. We had court orders and everything. My daughter took the stand, but we had to go through it to understand it. So now what I do, my children know I talk about this out loud. I said I got a TEDx talk. My daughter was very young. She was 7. I have been talking about this from day one. It is very hard to put your family on the spotlight. Everybody should not do it. I would not recommend it, but you can learn from those like you, Joel, cover these cases, like John and like Ryan. They're the experts. You all some of our folks here, they have a story. They're not saying it, but they have a story too. So thank you all. Thank you, Joel, for always. You have been one of the first people that put me on and out in this atmosphere on YouTube and, having me on your show. And I'm humbled. I'm grateful. And Ryan, thank you for the great work that you do in our state of Florida. Because I'm there too. And John, what you are doing in Indianapolis, I got family there too. So I've done some work there too. But thank you all for what you do. Thank you for your listeners, your followers. And Joel, thank you for creating a show and a platform that gives voice to victims who are silent and who need their platforms and their stories told, not necessarily from their mouths, but from those of the experts that you have on your show.
Feel bad for John and Ryan having to follow that one up. But look at this, La Mesa here saying Sonny for president, and I will definitely, I will vote. I'll vote for anyone who says nice things about me and my show. That's for damn sure. John Tompkins, coming back. You're gonna have to unmute yourself, John. I think in the car, hopefully not driving. I've been there. I see the child behind you. John, my final question to you is what happens with this? We found out, by the way, since this gap of time that you were not with us, that the trial has already been continued to July. How does the judge rule on this? Your final thoughts?
I think there's going to be some level of suppression. I don't know how deep into the fruit of the poisonous tree it will reach into the total evidence. I think it's a real shame people don't understand. I'll go back and add to what some of Ryan said, that criminal defense attorneys here are enforcing the law, that law being the Constitution. The people who have a problem with that, the short, uncaring answer is, if you don't like the United States, fine, move on out. What people need to understand is there needs to be better training for police. Defense attorneys shouldn't have to raise these issues, but we do have to raise them when they are there. We have to, because if we are not all safe under the Constitution, we don't have a great America. We simply don't. We have a place like Russia or China, and nobody wants to live in those places. I also want to expand on what Sunny said. It was wonderful hearing from her. An ounce of prevention is worth a pound of cure in situations like this. We all have to work at our homes and in our communities to encourage communications, to make people who are like this victim and her mother feel safe in talking to us, so somebody can reach out and help them before it gets to the stage where police are involved. And it's a shame that didn't exist around that community or in a place where this mother and child felt safe enough to talk to someone close to them to get involved before these events occurred. But once the events occurred, the Constitution is there to be enforced and to protect all of us. Defense attorneys are not looking to put criminals on the street. I often tell people, societies don't collapse because there are criminals on the street. That comes in all societies. There are criminals who haven't been caught. There are criminals who haven't been convicted. Society fails when people don't trust the systems that are running society. And when the criminal justice system, police, defense attorneys, and prosecutors are not functioning properly, people will lose faith in it, and then our society has a problem.
Well said. Some people don't like to hear from criminal defense attorneys, but again, John Tompkins and Ryan are the cornerstone, whether you love it or hate it, of our judicial system. If any one of us, and trust me, it's easy to get into trouble, especially today. Every single person I see in Miami is on their phone while driving. You can easily hit someone, kill someone, and suddenly you are reaching out for the Ryans and Johns of the world. I guess it's not that hard to get into trouble, which is scary, Ryan. This is Maddie Soto here, 13 years old. She never got beyond that age. She will be forever 13. Super sad. Ryan Vecchio has 6 kids of his own, twice as many as I do. Luckily, he's a very successful criminal defense attorney, and those kids will all be able to go to Harvard out of pocket. No scholarships, all out of pocket. Ryan, I'm sending my kids. I found out, I had no idea, being a Jersey guy, that Florida is as great a school as it is. And it's $8,000 a year. University of Miami, $100,000 a year for a kid to go to Miami. Florida's a better school. I'm already buying them Florida t-shirts and trying to brainwash them so they do that. Ryan Vecchio, you get the final word here. Do you agree, I have to ask, with John, that there'll be some level of suppression? And I guess, was it a big risk to have Stephan offer testimony today? Your final thoughts.
Well, they had to, because in Florida, the defense has to put on evidence in a motion to suppress that there was a warrantless search. So, and that it was a warrantless search of the defendant. So they had to do it. I think that the state is probably going to get past this one on sort of a mixture of consent and inevitable discovery, that they were independent routes that would have led them to the evidence. But at the end of the day, it's a tragic case, and no matter what amount of lawyering, and no matter what the state does, no matter what the defense does, so many people get wrapped into these cases. I mean, the reality of it is, no homicide prosecution ever brings back the loved one, and it becomes a whole notion of what is justice, because what is justice to the state is very different than what is justice to Stephan Sterns, to maybe even what a jury thinks, or a judge thinks, or the public thinks. And these are horribly emotional cases that can leave scars, because there are certain things you can't unhear and unsee. But I think coverage of these cases and these issues are very important, because somebody may be in a similar situation. There may be another Maddie out there that is seeing something like this on the internet, or another, not that I, want to sit down and have dinner with her, but there may be another Jen Soto out there that is going through this. And awareness is absolutely crucial to protection. So as we continue to follow the summer and the fall of Stephan Sterns, which is going to be a lot, I think it's important for everybody watching to take something away. And if that is protection, if that is integrity in our system, then it's worth the work that all of us at various aspects of the system play.
Some really sage advice tonight. Thank you to Sonny. Thank you to Ryan. It also reminds me what Sonny was saying, because look, law enforcement is kind of the first, to respond, obviously, to all this. Our friend Chief Chris Anderson, who's featured in First 48 Birmingham, he has a book out now called Man, You're Crazy, about the mental health struggles of first responders. So we'll get him on. And
that's my friend. Chris and I are friends. We go back from Birmingham. We have worked some cases and stuff together. He's great. He was hot in Birmingham and still hot now.
Yeah, he's the chief, man. He's a 6'6" teddy bear, that guy, but talks about how hard it is. And the Phil Waters, Scott Duffy, all these guys, they respond to these scenes, they investigate, and they have to see things that can never be unseen. So tread carefully. Thank you to STS. We're back tomorrow with this crazy story about Grant Solomon, who's died under suspicious circumstances. The father, who was a news anchor, was apparently is accused by the family of doing things to the daughter. Now the mother is arrested for a murder for hire plot against the former news anchor, so who's her ex-husband. Crazy story. We'll do that tomorrow night. And then Phil and Scott are finally back. We're going to look at the Taylor Shabiznis police interview. She is perhaps one of the wackiest individuals, an evil person, and we will look at that on Friday with Phil and Scott. Huge thanks again to Ryan. Huge thanks to Sonny. Sonny, we'll get you back on soon. Love you, America. Love you, Florida. Love you, Jersey. And it's justice for Maddie Soto. See you soon, everybody.
Take